The Guardian newspaper recently published the article that is on the screen now, which I have discussed in a previous video. This is essentially quite a favourable article towards the conviction of Lucy Letby being unsafe. However, there's a very short paragraph in this article regarding the Thirlwall Inquiry that may have escaped the attention of some people. So in this video, I'm going to discuss the importance of that paragraph, its implications, and context surrounding both the paragraph itself and more broadly the Thirlwall Inquiry as a whole. The first thing to say about the Thirlwall Inquiry, I'm sure many people know this who are watching this video, but it is simply a public inquiry that, as is stated here on the Thirlwall Inquiry website, has been set up to examine events at the Countess of Chester Hospital and their implications following the trial and subsequent convictions of former neonatal nurse Lucy Letby. In my estimation, it has been, to put it mildly, deeply unsatisfactory, but we'll get into that more as this video continues. I've been very fortunate that I've worked with a researcher during the process of compiling and writing my book, and the researcher and myself have looked at every single document from the Thirlwall Inquiry and all of the public inquiry. So everything that was ever said in the room in front of Lady Thirlwall and everything that was ever submitted to the Thirlwall Inquiry. So I have a pretty good impression of what occurred at the inquiry and the problems with the inquiry and the weaknesses of the inquiry and the things that the inquiry did not discuss that are in its documents. So the Guardian article begins here with this paragraph, which I'll just read out. It was striking that when the trials ended in July last year, amid the storm of publicity, a growing number of experts immediately spoke out in disagreement, even outrage, at the evidence that led to Letby's convictions. The government had rapidly set up a public inquiry chaired by the Court of Appeal Judge Lady Justice Thirlwall to learn lessons from how a serial killer had apparently been operating in an NHS hospital unit. Before it started, 24 distinguished specialists wrote to the Health Secretary, Wes Streeting, and Justice Secretary, Shabana Mahmood, calling for the public inquiry to be paused or widened to grasp the opportunity to consider whether the legal system may have produced a miscarriage of justice. So, from day one, it was made very clear to the organisers and operators of the Thirlwall Inquiry that the whole process that was about to be associated with this major public inquiry that's cost millions of pounds, tens of millions, in fact. I think it had cost £15 million already by September last year, and it hadn't even begun. I don't know what the final figure is, but it's clearly going to exceed 20 million. And of course, this was completely ignored, as we see here. But Thirlwall and the inquiry lawyers refused to engage with that possibility. In her introductory speech, Thirlwall dismissed the mounting concerns as noise. She had to focus on the inquiry's terms of reference and could not set about reviewing the conviction, she said. The Court of Appeal has done that with a very clear result. The convictions stand. Now, I don't think anyone was asking her to review the convictions, and I don't think anyone has asked for this at any time. Naturally, that is not her role or her remit. What they were saying was that incorrect conclusions could be drawn from the process if you don't look at the entire process in the hospital. And I think even, although personally for me, it was completely unsurprising how biased and how ridiculously structured to exclude certain information the inquiry was. That wasn't surprising for me at all because I've studied lots of inquiries in the past. I know how these things work. It may have been a little bit surprising for the experts, although probably some of them weren't particularly surprised. But the problem has been that the Thirlwall Inquiry has systematically ignored its own documents. Not just one or two, not just dozens, hundreds if not thousands, that paint a completely different picture of what actually occurred at the Countess of Chester to the narrative that's been communicated publicly through the mainstream media. So during this initial commentary, where she described the concerns as noise, Lady Justice Thirlwall also made reference to the families who were present, I believe, all the way through the Thirlwall Inquiry, or certainly at times, saying that questioning the convictions is causing them enormous stress, essentially an appeal to emotion, and also made this argument that the nurses' convictions have come entirely from people who are not at the trial. Now, she's not the only person that has made this comment about not being at the trial, and she's not the only person that's made this comment about there being, this kind of emotive or emotional argument about, oh, you shouldn't say anything because it's too upsetting for the families. I appreciate the families have been through an extremely traumatic experience, but I don't. Firstly, I don't believe that misleading the families is the correct thing to do, and secondly, regardless of how the families feel about it, you cannot just keep someone locked in prison forever because it's upsetting to someone. I mean, clearly that is just not acceptable. And if there was any other way to do this that didn't upset the families, clearly it would be preferable to take that route. But there is nothing else that can be done other than the route that is being taken. Now, Lady Justice Thirlwall here is arguing, oh, everyone should just keep quiet and just leave it to the system, which is essentially quite an elitist argument in and of itself. But we'll assess the validity of just leaving things to the system as this video unfolds. So these are the actual comments. Comments on the validity of Lucy Letby's convictions have created a noise that caused an enormous amount of stress for the parents of the victims, a judge warned on the opening day of a public inquiry. Letby, 34, was sentenced to 15 whole life orders after she was convicted across 2 trials of murdering 7 babies and attempting to murder 7 others. The inquiry at Liverpool Town Hall will examine events at the Countess of Chester Hospital's neonatal unit, where Letby was a nurse between 2015 and 2016. Opening the hearings, Lady Justice Thirlwall said doubts cast on Letby's convictions in recent reports had come entirely from people who were not at the trial. So with regard to that last comment, this has been made by other people as well, most notably Dr. Evans, who we're all familiar with, who is the lead prosecution witness. And essentially, here she's requesting something that is completely unreasonable, even unfeasible. Naturally, criticism has come from people who are not at the trial, because how can anyone conceivably be expected to attend every day of the trial and also be a leading medical expert unless they're actually in the trial itself? In which case they wouldn't be feasible for them to be an independent observer or independent critic. It's just not possible for people to attend every day of the trial. That's why it's so important going forward that recordings and proper transcripts, but I just believe recordings should be made available. Certainly transcripts should be made available, but I can't see any reason in this day and age why there can't be audio and video recordings of court proceedings. If you need to make people anonymous, far too many people were made anonymous for this trial. It was utterly ridiculous. It was completely unjustified. It should not have happened. But I appreciate some people needed to be made anonymous. That's fine. That can be done. There's ways to do that. I cannot see any conceivable reason in this day and age with the technology that's available and the distribution why court proceedings are not recorded in this country. And if that was the case, this sort of kind of slightly Weasley argument about, oh, you weren't at the trial so you can't have an opinion, that just means no one can ever have an opinion on anything that happened in court unless you're able to go to every day of a trial. Just tell, if you've got a normal job, just tell them, oh, by the way, this is an important issue and I'd like to be able to have an opinion on it, so I won't be able to come to work for the next 10 months. Preposterous, absolutely preposterous suggestion and completely unreasonable. So, really these 2 comments are quite a pretty low, in my opinion, appeal to emotion, and then just requiring people to do something that is completely impossible, otherwise they're not entitled to an opinion. Of course, Wes Streeting is another person who has made very similar arguments. You can see mentioned here, he's making reference to the grieving parents. And he recently, in these comments here, did everything possible to toe the line and say nothing of any substance whatsoever, which is usually the case with him. So I'm going to take a little bit of time just to examine Wes Streeting, his background, and what he said about this case. So, asked if he had reconsidered his previous comments that speculation on the former nurse's innocence was crass and insensitive, after an expert panel determined there was no medical evidence to support a conviction, he told LBC Radio, "It is still the case that Lucy Letby is convicted of the crimes she was accused of," he said, stating the bleeding obvious. "I know there is a campaign being waged, including by her legal team, to protest her innocence, and including some of my parliamentary colleagues. What I would say to those campaigners and to anyone else who's involved in the court of public opinion, as it were, is that there is a judicial process to follow." That's not the question you were asked. You weren't asked whether or not there was a judicial process. We know there's a judicial process. You were asked if you'd like to reconsider your previous comments. He said people who thought there had been an unsafe or wrong conviction should consider those grieving parents who have lost their babies. So how should we consider them exactly? What can we do other than point out the fact that Lucy is innocent? These are unsafe convictions and they need to be addressed as soon as possible. Obviously, we are considering the grieving parents because everyone feels a great deal of sympathy for them. And I will never be able to understand what they've been through. And I mean, there's been moments when I'm reading about what's happened to them, that the kind of trauma that they suffered on the wards and being in the rooms around the nurseries, and it's obviously it's horrifying, but that doesn't mean that we'll just allow this to be swept under the carpet and we'll allow Lucy Letby to be kept in prison indefinitely. Frankly, again, it's just a very transparent appeal to emotion from quite a gutless politician, in my opinion. And then he says, and pursue legal routes to have a case looked at again because it was not a political campaign, it's a legal process. So again, essentially making the argument of, not to put too fine a point on it, the peasants should just keep their nose out of it and just leave it to the King's Council. You don't need to have an opinion. Just go to work, pay your taxes, and shut up, is basically what he's saying. He added, "I still think that waging a campaign in this way, in the wake of those convictions, is not the right thing to do. Until I'm told otherwise by the courts of this land, then I continue to stand by the view that there's been a fair conviction here. Until the courts determine otherwise, that's how justice in this country works." On one level, you could argue that's a fair opinion, and obviously he will hide behind the fact that he's a government minister and it's not appropriate for him to have an opinion, but he already has offered an opinion. He's already said that people that are talking about this are crass and insensitive and that we're just upsetting the families unnecessarily. So on the one hand, he wants to have an opinion, but then on the other hand, when you actually ask him to have an opinion of substance, he then hides behind the fact that he doesn't have to have an opinion or isn't supposed to have an opinion because he's in Parliament. So it's really a case of having your cake and eating it here. So previously, Streeting had declared himself to be with the families on this, as if people that understand that this is an unsafe conviction and people that strongly believe that Lucy Letby is innocent are somehow against the families. And then he goes on to say, "I can't imagine the unbelievable grief they're going through without the constant speculation whether someone who has been convicted for these murders with whole life sentences being effectively presumed innocent by a number of people. Out of respect to the families, do it quietly. I actually think it's crass and insensitive to wage a public campaign in this way." So I think that's a very unfair statement for numerous reasons. I think, firstly, he's implying that people that care about Lucy's plight don't appreciate the unbelievable grief that the families have been through. Secondly, he's labelling this as constant speculation rather than what it is. There's scientific information, there's considerable evidence that all points to this being an unsafe conviction and something absolutely appalling has happened. And for me, it's if you want to play the game of appealing to emotion, then the fact that he can't give any consideration or show any empathy whatsoever towards someone who's in prison indefinitely who may have been wrongly convicted, I think is a pretty poor state of affairs. It's not surprising to me, but I do think that perhaps he's not quite as well placed to take the moral high ground as he thinks he is. So there's a reason why it's necessary to have, as he describes it, a public campaign and to publicise the situation with Lucy Letby. And one of the primary reasons for that is on the screen now, Andrew Malkinson. Andrew Malkinson served 17 years in prison for rape, and not only was he innocent of this crime, he definitely wasn't at the crime scene at the time that the offence occurred. Someone was genuinely raped, there was genuinely an attacker. It definitely wasn't him because he definitely wasn't there. And when we look at the Malkinson case, which I'm now going to do in a little bit of detail, we see that leaving things to the system and just being very quiet in the background, as Wes Streeting suggests we should, doesn't always work out particularly well. So in the case of Andrew Malkinson, he obviously didn't have the level of support that Lucy has now. It wasn't publicised until, I think, right until him being exonerated. I never heard a single thing about it until he was exonerated. Certainly, if it may have been in the media in a fleeting way, I'm not really sure, but certainly it wasn't a big story or something that people were generally aware of. And in these next few slides, you will see very clearly the consequences of not having a public campaign and what happens when you just leave it to the system to dispense justice. So documents in the case of Andrew Malkinson show the DNA of another man was identified 3 years after he was wrongly jailed for rape. This is a BBC article, a recent BBC article. Mr. Malkinson was found guilty in 2004 of raping a woman in Greater Manchester and only had his conviction quashed last month at the Court of Appeal. So he could have been potentially exonerated 3 years into his sentence. Frankly, when you look at the evidence, the case shouldn't have gone to court in the first place, in my estimation. Very, very poor evidence. The only evidence they ever had was an eyewitness account, and I believe that it was proven that eyewitness account came from a heroin addict. What is definitely known to be true is that it was extremely inaccurate. And literally, if you go back and look at the case, there's no other evidence. They just assassinate his character in court. It's actually disturbing and chilling to realise the extent to which the prosecution service is happy to do that. And when you think about it, this case has to be passed the Crown Prosecution Service, and they have to make a decision on whether there's good enough evidence. Now, of course, they may lean strongly on the fact that there was an eyewitness account, but if they think there was enough evidence for this case to go to court, it's basically a formality that Lucy's case is going to go to court. It would make me wonder when they will turn down a case, when they will look at the case and think, well, there's not enough evidence for this to go to court. I would love to know under what circumstances they would do that. Anyway, the point is, it took, 19 years? 19 years for this conviction to be quashed. Andrew Malkinson served his entire sentence. He actually could have reduced his conviction by stating that he was guilty, but he said, I won't do that because I'm not guilty, and of course he was proven to be correct. But this BBC article introduces the idea that DNA was available. So there's a little bit of a timeline here in The Guardian. CCRC case log summarises a meeting with forensic scientists and says they said, we are not going to get a profile from the material available, which is capable of being searched, and as a result, someone identified. On the face of things, this tends to support the position that the Commission has done everything reasonable, and there is no convincing reason to take forensic investigation any further. However, searchable DNA had already been found and searched in 2007. Later that year, case log showed the significance of the location of saliva on the vest top appears to have been missed by the CCRC, despite the Crown Prosecution Service acknowledging its significance as crime-specific 2 years earlier. The note says the location of the DNA on the vest top does not make it any more likely to have been left by the attacker as opposed to a different individual. The CCRC refuses Malkinson's 2009 application without looking at the full police file or commissioning further DNA testing. So he served another 9 years, 10 years from that point, even from 2012, where they can look at the police file, they can commission DNA testing, they can look at this sample they've already got, and they just refuse to do it. And because of that, he was only exonerated 11 years later, and he served his entire prison sentence. And it's no picnic being in a men's prison as a convicted rapist. It's not something I would want to do. So as you see here, there's a further reference to the police and Crown Prosecution Service having key DNA evidence 16 years before Andrew Malkinson was cleared of rape. And the fact that no action was taken when they knew that they had this, it's hard to describe that in any other way other than them withholding evidence. So there's a bit more detail here. Case files released to Malkinson as he fought his conviction, and now seen by The Guardian, revealed that police and prosecutors knew forensic testing in 2007 had found a searchable male DNA profile on the female victim's vest top that did not match Malkinson's. They decided not to take further action. There is no record they told the body responsible for investigating miscarriage of justice, though Malkinson's lawyers were notified. The DNA discovery was made in 2007 as part of a nationwide review of the forensics used in historic rape and murder cases called Operation Cube. Malkinson, 57, was convicted of a stranger rape in Manchester in 2004 on the basis of witness evidence, with the prosecution arguing he left no DNA because he was forensically aware. He always maintained he was innocent. Yet the discovery of another man's DNA, which was not that of the victim's then boyfriend in a crime-specific area of the victim's clothes, did not result in the CCRC referring his case for appeal. During the attack, the victim suffered a bite that partially severed her left nipple, meaning saliva staining on the vest above the left breast was considered crime-specific by the Crown Prosecution Service. A log of a meeting between the Forensic Science Service, the CPS, and Greater Manchester Police in December 2009 reveals that the CPS was aware of the potential enormity of the discovery. Its then head of complex casework in Manchester said, "If it is assumed that the saliva came from the offender, then it does not derive from Malkinson. This is surprising because the area of the clothing that the saliva was recovered from was crime-specific. However, he said he did not see that there was a need to do any further work on the file unless the case was brought to appeal, and then his focus would be on bolstering the case against Malkinson." So this is an absolutely extraordinary morsel of information about the way that the organisations that are part of the system that administer the criminal justice system, that prosecute people, actually operates. And yet Wes Streeting, and essentially Lady Thirlwall as well, are asking us to just shut up, essentially, and just leave the system to deal with it. This is despite this case. This is despite other cases that I'm going to go on and discuss. Despite something like the Hillsborough inquiry, where it took, I don't know, was it 30 years to get any kind of admission about what actually happened? And even then, no one in the police was ever properly prosecuted. Same with the Birmingham 6. The police were never properly prosecuted in that case. They've had almost no consequence in this case. We're going to go on to see what happened with the CCRC. There have been some consequences in the CCRC, Criminal Cases Review Commission, and hopefully they're going to do a better job going forward. I cannot say that they will do a better job going forward with any confidence, but it's incredible that you can have a situation like this where there's a person in prison for rape, they serve 17 years, and someone can state there's no need to bother doing any further work on the file, even though we have DNA that could clear and release this person. And let me emphasise this, there was no DNA in the original case, so they never had any concrete evidence from Malkinson. It was just an eyewitness account, that was it, literally. There was nothing else at all. That's why there was no forensics. So to just ignore that and just say, oh, we're not going to bother doing anything, and if the case is brought to appeal, we'll just focus on bolstering the case against Malkinson. It just shows how little regard these people have for actual justice and how little seeming appreciation they have for what the actual role of the police is supposed to be. The police are not there to secure a conviction and say, oh, look, we got a result, that's great. The police are there to investigate things dispassionately and get to the truth of the situation. When you read these words, is it that surprising that the police made such a pig's ear of Lucy Letby's investigation? Or did they in fact make a pig's ear of it? Or did they do what they've done many times before and will do many times again in the future? So it goes on. Emily Bolton, Malkinson's lawyer at the Charity Appeal, said, "The documents are a shocking chronicle of how Andy was utterly failed by the body, which should have put an end to his wrongful conviction nightmare, but instead acted as a barrier to justice. An overhaul of the CCRC is needed to prevent it failing other innocent prisoners. By relying only on the CPS file, the CCRC missed the chance to identify disclosure failures so grave that senior judges have since ruled they would have rendered his conviction unsafe. It was left to appeal to uncover disclosure failures and commission more forensic tests. Without the CCRC's automatic access to police files, they had to take extensive legal action against Greater Manchester Police to access them. Refusing to refer his case for appeal in 2012 and explaining why it would not conduct further DNA testing, the CCRC told Malkinson the cost of forensic investigation was not its overriding consideration. Yet the internal case log reveals the CCRC made comments, including the cost cannot be ignored and further work would be extremely costly. Malkinson said, if the CCRC had investigated properly, it would have spared me years in prison for a crime I did not commit. I feel an apology is the least I am owed, but it seems like the very body set up to address the system's fallibility is labouring under the delusion that it is itself infallible. How many more people has it failed? I think we can conclude quite reasonably that it's failed many other people. So bear in mind that when Wes Streeting is saying, oh, we should just all leave it to the system and everyone should shut up, essentially, that this is what the system did previously. The system had a person who was undeniably innocent. It's not even a case where he could be said to be not guilty. It's proven now there's DNA evidence of someone else who is not him at the crime scene that is crime specific, as described by lawyers. So he's absolutely innocent. And not only was this information withheld, not only did they not do a forensic investigation that could have cleared him, but they openly stated that firstly, it would cost too much money. Secondly, that they didn't want to do it. And thirdly, that if there was an appeal, they'd just try to bolster their case against him. So that's how much faith we should have in the system before we look at any other cases. As a final pillar to the Malkinson case, I will just mention that he was exonerated in July 2023. And the Criminal Cases Review Commission finally managed to apologise, just say, soz mate, sorry about everything that happened, in April 2024, 9 months later. So you think, obviously the police issued an apology. It was mostly them defending themselves, but they at least, I think this was the least that they should have done, but they at least managed to do it on the day that he was exonerated. It took the actual legal system 9 months to say, oh, we offer you an unreserved apology. Would it have been that hard to get that out back in July 2023? It took 9 months to say that. So it's pretty incredible. And that's what you're dealing with. And that's why it's necessary to put public pressure on the system. That's why there does need to be a campaign. Because if you just allow things to go on quietly in the background, this kind of thing will happen. It's as simple as that. So another recent case that I'm sure many of you are aware of is that of Peter Sullivan. Just a little bit of an article here. I'm not going to go into his case in depth. He's been completely exonerated by DNA evidence. He spent 38 years in prison. So, I mean, half of his life is gone, assuming he lives to the kind of average age that a male would. He was, what would he have been? I think he was in his 60s. So he's 68 now, so he would have been 30. So I suppose you could say at least he got to spend his 20s not in prison, but you know, his 30s are gone, 40s are gone, 50s are gone, 60s are gone. Oh, by the way, we screwed up. Never mind. You know, and then there's the post office inquiry, and this only occurred. The compensation related to the post office inquiry that only really occurred because of the television programme that's on the screen now. If that Mr. Bates versus the Post Office, ITV1, mainstream television, is it the most watched TV channel? I'm not really sure. If that hadn't have been on TV, it would have been delayed hugely, or it wouldn't have come into the public consciousness. They may not even have been compensated. There's a bit of a record of it here. This document, the TV program came out in January 2024, and then it was in the media, and then things started happening, is essentially what is stated here. And the problem that Malkinson had, and the problem that Peter Sullivan had, was no public campaign, no public pressure. Therefore, so much media coverage, so much communication, so much discourse from the government, from the criminal justice system itself, is on communicating, we're always completely correct. This is the criminal justice system. It's been in place for centuries. We've been operating the way we are now for several hundred years as well. It's one that often in Britain we tend to hear this. It's the best in the world. We've got the best healthcare system in the world. We've got the best criminal justice system in the world. We hear it over and over again. So, I don't think that is particularly well founded. I accept there are problems in other countries' criminal justice systems, but this constant assertion of the pedestalization, you could describe it as, of the criminal justice system is deeply inappropriate because it's not that great. There are loads of mistakes made. They're good at prosecuting open goal cases in which someone is clearly guilty and they try to wriggle their way out of it. They're good at doing that. They're not good at dealing with complex cases. They're not good at dealing with cases with science. And they create a lot of miscarriages of justice because the police quite evidently think that their job is to secure a conviction. And so once they have a target in their crosshairs, they just go all after that target and they don't consider anything else. Seeing that in Lucy's case is yet another example. And I think the comments that the fact that they didn't want to investigate this further, Greater Manchester Police basically did not want to investigate this matter further because they thought it was better for them and more important that they had secured a conviction, and if it was questioned anyway, it would make them look bad. That's essentially, they're happy. Once they got a conviction, someone's banged up, they bang people up every day. What does it matter to them? They don't care. And there's actually a case, I think it's the Paul Blackburn case, where he was exonerated, released after 25 years in prison, and Cheshire Police refused to apologise. So the idea that we can just leave things to the system, we can just leave things to the authorities, we can just, as I say, go to work, do shopping, get taxed, and just shut up, as Wes Streeting is essentially suggesting, is completely flawed. And we know that from very recent cases. So I just wanted to finally mention the issue of compensation. So Andrew Malkinson finally received his first compensation payment in February 2024. This is presumably solicitor Hickman and Rose talking about his statutory claim to be compensated. This was many, many months after he'd applied. He was actually living in a tent for quite some time, absolutely destitute, having had his life ruined. I believe now charging people bed and board for being in prison has been removed, but I couldn't say that with any confidence. And this was actually just very recently, Sir David Davis pointing out that 93% of victims of miscarriage of justice cases are refused compensation. And I actually heard someone on the radio who was representing Peter Sullivan. I think it was on 5 Live. I only heard the end of it, so I didn't hear the whole thing. But I think that person was basically saying that it's not inevitable that Peter Sullivan will receive compensation, having been wrongly convicted of murder and been in prison for 38 years. So with regard to Wes Streeting, I just want to go over this very quickly. So this is some information about his voting record in Parliament. Now, I will point out there's a small mistake in this, which I'll come to in a second. It was difficult to find any other visual way to demonstrate this without trying to create a diagram myself, and I have no ability to do that. So I thought this would be the best way. But this is some information. So according to data from the Public Whip, he has rebelled in a small number of votes. So basically, in every vote from July 2024 to the present, that he voted with the Labour Party. That's not correct, so I'll come to that in a second. Between December 2019 and May 2024, he did not rebel in any of the 632 votes he attended. That is correct. He didn't rebel in hardly any of these votes, but I just wanted to focus on this recent period, the last 6 years. So that first statistic is not correct because he did vote against the Labour Party on the 29th of November 2024 on the terminally ill adults end of life bill. And I want to give him credit for that because I've spoken to people with regard to this, and whichever side of this issue you come down on, I was told there are things to be seriously concerned about in the legislation. So, I do respect him for going against the party on that occasion. I have mixed feelings about it, but this video is not about the terminal ill. We'll maybe discuss that in the future. The point is that out of the last 645 votes that the Labour Party have made, or that he's attended, he has gone against the Labour Party once in 645 in 6 years. So This, while you would expect most MPs, virtually all MPs, to support their party and go with the party most of the time, you expect them to occasionally have a point of principle, or they should fairly regularly, I would say, have a point of principle where they vote against. This guy, so there's 719 here and 645 here, so you're looking at 1,364, and he's voted against the Labour Party 5 times in 1,364 and once in the last 645. So this is the definition of a system server, which is why you see him making these comments about we should just respect the criminal justice system. We should just accept the Court of Appeals made a decision. He's just a guy who has political ambitions. He just wants to be the Prime Minister, and he'll just do whatever he is required to do and toe the line and never cause any problems. As soon as Lucy Letby is exonerated, he'll still have another party line that he has to come out with. Really, he just has no authenticity or honesty or integrity, I would suggest. You can't possibly, out of 645 things that have occurred, he's only disagreed with one of them. It's just not feasible. So to return to the Guardian article, I'll just read this passage on Thirlwall out. For 6 months, until the hearings finished in March, the inquiry proceeded on that basis, an unchallengeable assumption that the prosecution case was right and that the truth was only established once the police become involved. The scale and weight of the expert challenge to the criminal trial have not been acknowledged by Thirlwall and her lawyers, by Streeting, Mahmood or any government minister. The legal and political establishments appear to have struggled to recognise that the concerns over Letby's convictions are far from conspiracy theory or internet noise. And that's a very generous assessment to say that they've struggled to recognise that the concerns are legitimate. I think it's not so much that they've struggled to recognise this, it's that they just do not want to address it. They've closed ranks and attempted to block the legitimacy of this. It's clear that these are very legitimate concerns. They couldn't possibly be unaware of that or struggle to recognise it. I think it's a very generous assessment. It is unprecedented that so large a group of experts with such distinguished reputations have so rapidly, publicly and comprehensively spoken out to dispute convictions for murder. I'll just mention as well briefly that the article here obviously states that the concerns are far from conspiracy theory. I just want to mention that David Wilson specifically used this phrase in an obvious attempt at smear tactics, and they're just saying here that is ridiculous. So just wanted to make that clear. The lawyers representing the parents of the Chester babies at the Thirlwall Inquiry have criticised the raising of concerns and said they are increasing the family's distress. Now, I've actually been over the statement that the lawyers have released. That was the very first thing I did on this channel. There's a playlist related to the Thirlwall lawyers where I've gone over every claim that they've made and dismantled every single one. What they wrote in that document was, for the most part, utterly ridiculous, and some of it is a little bit less than utterly ridiculous. It's just very poorly founded. They have dismissed the possibility that Letby could be the victim of a miscarriage of justice and don't accept that Lee's panel's work or his new research may undermine the safety of the convictions. I mean, essentially, they're just doing what they have to do to get money. It's not that they actually believe what they're saying. And I've already outlined the fact that Mr. Simon Driver is involved in that group and was involved in the prosecution case and will be involved in the prosecution when it goes to the Court of Appeal, which, in my view, is just a very clear conflict of interest. And obviously, they know it's a conflict of interest, which is why they've actually acknowledged it as well, as I mentioned in a much earlier video that you should have a look at if you get time. On the 18th of March, Kate Blackwell KC, representing Harvey and 3 other hospital executives at the time, applied for Thirlwall to pause writing a report, arguing that the purpose of public inquiry to fully and fearlessly establish the truth would otherwise not be fulfilled. Blackwell's stance signalled that the executives, who have been relentlessly criticised at the inquiry for commissioning the external reviews and not going to the police sooner, questioned the safety of the convictions. It was the final day and the first time anybody involved has said the experts' concerns should be taken seriously. Streeting and Thirlwall refused the application. So there's a lot of information there, but I think the most important thing is this notion that the inquiry relentlessly attacked the executives. There was a very clear narrative put in place in this inquiry from day one. The first is nothing ever may be allowed into the public inquiry that contradicts the guilt of Lucy Letby and the conclusions of the court. The second one is that the executives who worked at the hospital must be blamed for everything. Now, there's going to be a lot more information coming out about that in the future. I can't really talk about it too much at this point in time, but I do know someone who attended quite a bit of the Thirlwall Inquiry, and she told me that the relentlessness with which they attacked anyone that went against the narrative was incredible. And similarly, there was just a blanket refusal to go against the narrative of the inquiry from day one. The narrative of the inquiry from day one has been laid out by the person on the screen there. It is that Lucy Letby is definitively guilty. No one should be allowed to say any different. Anything else is just noise. Everyone should just shut up and not interfere in any way while we completely blame everything on Lucy Letby and the executives that ran the hospital. And because I've seen every single document from the Thirlwall Inquiry, and because I've had a researcher help me in that process, I know how inadequate and how poorly founded this is, and I know how many documents there are in the Thirlwall Inquiry that firstly contradict this notion that it was completely the executive's fault, and secondly, that contradict the scientific evidence that was provided in court. And those documents are there forever. We've got them all now. There's nothing they can do about it. Even if they delete the Thirlwall Inquiry website, they've been archived elsewhere. So that cat's out of the bag, and it can never go back in the bag. And the more that I researched these documents, the clearer it became how much they contradicted what has actually been communicated publicly to the general public through the public inquiry and through the media reporting of that inquiry. And I think the level of scrutiny and criticism that's been levelled at the executives from the hospital, Tony Chambers and Ian Harvey, is awful, frankly. So there's this article here from the Daily Telegraph where Ian Harvey reveals he had to leave his French home following what he described as intolerable scrutiny. So he must have been being harassed at his house, which is despicable when he's done absolutely nothing wrong. In fact, he behaved and acted in a way that was entirely appropriate and professional. So now to come on to it's just a little 3 lines in this Guardian article that could have passed by very easily. And I don't think, it's not something I've seen being highlighted too much, but it was something that I believed would happen from day one before the inquiry even began. And then when the public inquiry began and I saw the way it was heading, the way it was being conducted and the narratives that were being injected into it, essentially, to use an ironic phrase, I could see that I was going to be right. So I'll just simply read out these 3 lines. Thirlwall continues to work on her report. She appears certain to recommend that, in future, if any accusations are made of wrongdoing by people in healthcare settings, they must immediately be referred to the police. Now, I expected this from day one. I wrote this online. I predicted this. This isn't surprising to me at all. That doesn't mean that it's not extremely dangerous. So if this is correct, and I assume The Guardian has inside information, I assume that they've approached the Thirlwall Inquiry, I assume they're not just deducing this from reasonable observation, as I am. I don't have inside information on this issue, so I don't know. But I've always suspected this would happen. I assume The Guardian does, or has had a nod anyway. So assuming for the sake, but anyway, we don't know that one way or another, but assuming for the sake of argument this is correct, what it would mean is, if anyone in a hospital, or indeed any healthcare setting as it's described here, just goes up to an executive or, an administrative department of that healthcare setting and says, I reckon this person has been maliciously harming infants, then, or anyone, it can be anyone of any age, of course, that should be referred to the police immediately. It should be immediately treated as a criminal matter. Just if someone says, I saw Susan do something the other day, that's it. It's got to go to the police. If it doesn't go to the police immediately, the executive runs the risk of being prosecuted themselves. And that is a terrifying precedent that is being put in place. Now, on one level, one might hope that if they're entirely frivolous referrals, that they will be the police will work this out and nothing will happen, and perhaps even the person that referred them will get into trouble. Although whether that would actually occur, I don't know, because the culture that's going to be created is, if you suspect any wrongdoing, report the person immediately, then it goes straight to the police. So that could lead to a very paranoid culture in which people think they need to refer things for no reason. The obvious danger of this is that if you get a gentleman involved, like, that's the wrong slide, hold on. Now, if you get a gentleman involved like this, like Dr. Evans, who immediately walked into the police station and immediately decided there was inflicted harm, then even a frivolous referral can go very, very wrong. And instead of a kind of medical, it should always be like a medical investigation, not a criminal investigation for a matter like this. To say that any time there's a small spike in deaths, or in fact, there doesn't even need to be a small spike in deaths, apparently. There just needs to be some belief that someone may have engaged in wrongdoing. As soon as the belief exists that someone has engaged in wrongdoing, it ceases to be a medical matter and becomes a criminal matter immediately, and the police investigates. The dangers of this are obvious. Even if we hadn't had this cast iron example of Dr. Evans walking straight into the police station and spending 5 years concocting the nonsense that appeared in this court case, this is a phenomenally dangerous thing that is being proposed. Now, I just skipped over these slides earlier, but there's already a nurse on remand in Birmingham. 3 sudden child deaths have been investigated at Birmingham Children's Hospital following the arrest of a nurse accused of poisoning. Now, this nurse has not been charged yet, and I would suggest the reason this nurse has not been charged is because they're waiting to see what happens with Lucy's case before they make a decision. And the Birmingham police are thinking, hold on a second, we don't want to be in the position that Cheshire Police are in now. So, but you see exactly the same pattern here. Dr. Fiona Reynolds, Chief Medical Officer at Birmingham Women's and Children's NHS Foundation Trust, said the findings have been shared with police. We have communicated with all families where the care of their child has been reviewed and have responded openly to all requests from West Midlands Police and the coroner on this matter, she said. At all times, our priority is patient safety, which is why we took decisive action without delay. This compromises patient safety. You can easily see there's going to be many more of these referrals occurring in the future if the Thirlwall Inquiry is allowed to do what it's apparently proposing to do. Incredibly dangerous. And patient safety, as I say, is compromised because there should be a medical investigation. Now, they may argue there's been some sort of medical investigation. I don't know. But according to what we've just seen in the Guardian article, that doesn't even occur anymore. It just goes straight to the police. As soon as there's a few deaths, as soon as someone thinks, oh, well, I don't like the look of that, or as soon as someone thinks, well, it could be this person, or this person's been acting a bit strange, or someone could even, in the case of Lucy Letby, Dr. Breary has assembled this so-called drawer of doom that he mentioned, although he never actually passed any of this information on to the police, incidentally. Someone can, and I'm not saying that he was maliciously trying to frame Lucy Letby, but it would be easy for something like that to occur. It would be easy for someone to think, right, I've got it in for that person. I'm going to try and get some information together to try and frame them. Then I'm going to go to my executive team, act really concerned, and they'll have to refer it to the police. Anything can happen. I mean, the gloves are off in terms of what's going to occur. We're already the serial killing nurse capital of the world. God knows what would happen if this is enacted. So the other thing that I wanted to say about the Birmingham issue is that I can guarantee it's extremely similar to the Lucy Letby case and the Colin Norris case and other nurse serial killer cases. And the reason that I would say that is if they had any concrete evidence, they already would have charged this person. So it's a poisoning, so it almost certainly will be insulin, almost certainly. And then on top of that, it will be, oh, we saw some readings that we didn't like, and oh, this person was on duty a bit more than she should have been. And before you know it, she's in the police station. And this is before they've passed this legislation and before they've issued the recommendations that the Thirlwall Inquiry are going to put out. And I can say very confidently that The Guardian will be correct because I've observed the public process, I've been through the documents, I've spoken to people who are at the Thirlwall Inquiry, and I know how these inquiries work anyway. So I can say very confidently that they are going to make these recommendations. So what we're essentially facing here is a race against time. This is something that it goes beyond people being innocently fingered for crimes. Of course, that's extremely serious. But it really, excuse me, it really is compromising patient safety across the NHS. And actually, if you're watching this video and you believe Lucy Letby to be guilty and you have children, please be advised that if Thirlwall implements these recommendations and if it becomes law and if it's put into legislation by the government, your child will be less safe in a hospital than it is now. That's just a fact. Because instead of having medical investigations when there are problems on a unit or when the number of deaths increase, instead everything is going to be referred to the police. That can happen so quickly. All it needs is, well, we don't like these figures. Well, we need to refer it because legally if we don't refer it, we're breaking the law. That will begin to happen with regularity, I would suggest. And you can see here in this case as well, that you talk Birmingham Police, they're acting quite correctly, obviously, in supporting the family. I understand that. But in Operation Hummingbird, as it's described, the investigation into the Countess of Chester, we saw the police, Cheshire Police, quite clearly becoming far too close to the families and completely failing to comprehend that their role is not to support the families and treat the families like a customer. It is to dispassionately investigate all of the circumstances at the hospital. They singularly failed to do that. In my opinion, and I'll be covering this in future videos, they became too emotionally involved and it became about getting a result for the family and getting a conviction. And that's not what it's about. But we're seeing exactly the same thing here. Same pattern. I can guarantee there's no concrete evidence. It's probably going to be an insulin poisoning. It's probably going to be a circumstantial case. I would say with 99.999% likely it's a circumstantial case. It's going to be, oh, we didn't like the figures we saw. Oh my God, this nurse did some extra shifts and now she's on duty a lot. She must have poisoned people. And now they're telling the families, oh, sorry to inform you this, but someone might have poisoned your kids. And this could happen. I don't know to what extent it would increase. You would hope if cases are referred to the police incorrectly or frivolously that they'll perform a competent investigation. But I have no faith whatsoever in the police to investigate any cases of this nature with any degree of competence. So in February of this year, Sir David Davis wrote to the Thirlwall Inquiry requesting the inquiry to be paused. That has yet to occur. It definitely should occur before they publish the recommendations. Whether or not that will happen remains to be seen. But I wanted to read this letter out to show the way that he expressed his concerns and how these concerns are now magnified by what is written in the Guardian article. Dear Lady Justice Thirlwall, I am writing to request that your inquiry into the events of 2015 to 16 at the Countess of Chester Hospital be paused, given the serious questions now being raised over the safety of Lucy Letby's conviction in August 2023. The terms of reference for your inquiry were agreed in November 2023, immediately after Lucy Letby's conviction for what appeared to be horrific crimes targeted against some of the most vulnerable in our society. However, since then, unprecedented focus has been brought on the evidence used to convict her. Questions have been raised by a multitude of experts who are recognised as leading practitioners in their respective fields as to the safety of her conviction. I wrote to you on 29th of August 2024 to express my reservations about the inquiry continuing with the terms of reference as agreed. My explicit ask in the letter was that the terms of reference be broadened so as not to depend on the presumption that Miss Letby's conviction was safe. In response, on the 2nd of September 2024, Tim Suter, the solicitor to your inquiry, dismissed that request. Since my initial request, the doubt over Miss Letby's culpability in the deaths at the Countess of Chester Hospital has only grown, as too has the evidence supporting that doubt. At the start of this year, an international expert panel convened by Dr. Xu Li outlined their findings after reviewing the evidence in Miss Letby's case, including the medical notes of the deceased babies. The panel concluded that Miss Letby did not murder any of the babies, stating that in all cases death or injury were due to natural causes or just bad medical care. The prosecution relied on Dr. Lee's evidence in Miss Letby's original trial, referencing a paper he wrote in 1989. According to Dr. Lee, this evidence was misrepresented. Aside from Dr. Lee, his international expert panel included leading neonatologists and paediatric specialists from around the world. Their combined experience far exceeds the experience the experts relied on during Miss Letby's original trial. These are by no means the only experts now questioning both the evidence used during the trial and Miss Letby's guilt. Leading neonatologists here in the UK have also reviewed the medical notes for two of the babies and have found that either natural causes or errors from the treating clinicians are likely to be alternative causes of the tragic deaths. We also now know that several alternate explanations for the deaths were not put to the jury, including that the neonatal unit was simply not up to caring for these fragile children in terms of either resource or skill. This shortcoming might have been compounded by other factors, such as a Pseudomonas infection the hospital was battling at the time. The Royal College of Paediatrics and Child Health report from November 2016, which was not presented to the jury, makes very plain those concerns. Given the weight of evidence now questioning the narrative presented to the jury in the original trial, an application has been made to the Criminal Cases Review Commission to refer Miss Letby's conviction back to the Court of Appeal. Your inquiry was tasked with looking at the conduct of the Countess of Chester hospital staff and management, specifically regarding their approach to concerns about Miss Letby and the effectiveness of NHS governance and culture in keeping hospitalised babies safe. Should the Criminal Cases Review Commission refer the case back to the Court of Appeal and Miss Letby's conviction is later found to be unsafe, your inquiry's report and recommendations, whatever they may be, would be based on a false premise. So I guess that's a particularly critical paragraph. I believe it's inevitable that Lucy Letby will be exonerated. I just don't know when it will happen. I hope that it will be sooner rather than later. But as Sir David Davis rightly says here, the whole report and recommendations of the inquiry will be based on a false premise and the false information that is the kind of inevitable outcome of that false premise. And now we're seeing what the recommendation will be. The recommendation, or one of the recommendations, will be that any concerns about any wrongdoing in any healthcare setting under any circumstances will be referred to the police immediately. And this is a calamitous prospect, not merely for people's well-being, but for the functioning of the healthcare system. I mean, I've written in my book that I believe that it seriously compromises. It puts the future of the NHS in jeopardy. I don't think that's too strong. I can't remember exactly how I wrote it, but I definitely wrote words to that effect, and I will stand by that opinion because it's already tough to get people into nursing as it is for obvious reasons. It's a really tough job. It's not got a fantastic salary. It's got a decent salary, but for the amount of work you do, the amount of responsibility you take on, the hardship, the emotional hardship, it's nowhere near. And then now it seems that you can be fingered right, left and centre for, just if someone sees something they don't like, or if the number of deaths spike a bit, you could find yourself in a police station, and we now know how well the police investigate these cases. Although people that knew more about this than me, that have been involved in the past, knew that it has been done in several cases previously. I didn't know that. I didn't know about the cases in this country. I didn't know about the cases in other countries, but obviously I do now. And this is all being done based on a false premise. To continue the letter, it will mean the alternative hypotheses will not have been given due consideration by your inquiry, and the issues in the provision of healthcare and governance at the Countess of Chester, which may be the true causes of the deaths of the babies, will have gone unaddressed. It will be a missed opportunity to correct and learn from these issues to prevent similar tragedies from being repeated in the future. This, in turn, may result in failures in neonatal units up and down the country being allowed to continue unchecked, resulting in further baby deaths. These failures are something that, in any event, are becoming more and more apparent. Put simply, an inquiry predicated on the presumption that Lucy Letby's conviction is safe, when there is now a wealth of authoritative voices questioning that conviction, will only undermine the conclusions arrived at by your inquiry and potentially lead to more babies dying unnecessarily. I therefore request that, considering the extensive new evidence available, your inquiry be paused until Miss Letby's avenues of appeal have been fully exhausted and the new evidence has been allowed to be properly tested before a court. I would find it very difficult to disagree with a single word of that letter. And I think, if anything, it's quite a moderate assessment, even though it makes, for example, I think the absolutely correct claim that this is going to put more babies at risk. That should be serious enough in itself. But I think it has institutional consequences, that potential institutional consequences that go even beyond that. And I certainly think it would lead to people leaving the nursing profession pretty rapidly. I know that there's evidence that the number of nurses is already in decline, and that they're struggling to recruit people, certainly from Britain, to work as a nurse. And frankly, is that surprising? No, it's not. Finally, I want to discuss this document, or just show you something rather that's in this document that was submitted to the Thirlwall Inquiry. It's INQ 01022998_02-03. And this is the initial meeting that the Cheshire Constabulary held, its meetings from that minute, the very first meeting of Operation Hummingbird. This is very shortly after the case had been referred. A letter had been sent by Tony Chambers to Chief Constable Simon Byrne on the 2nd of May 2017. This meeting's been held on the 5th of May. So right at the end of this document, I'm just going to zoom in so you can see this very clearly. As part of the review, staffing was looked at. There was a notable high statistical relationship between a member of the nursing staff and babies deteriorating in the unit. There is no evidence other than coincidence. So this case was passed to Cheshire Police with no evidence at all. Just, oh, Lucy was on duty quite a bit. That was it. So without Dr. Evans walking in and saying, oh my God, there's definitely been inflicted harm here, this case never would have progressed any further. Now, I can't discuss the background of what happened behind the scenes at the hospital or the police any further. I'll just say there's going to be more stuff coming out. So that's the situation we're in currently. We're literally in this situation where the person on the screen now is going to make recommendations that if there is any suspicion or any concern about anyone working within the healthcare system in any setting, that should be referred to the police immediately. Now, as I said at the start of this video, or earlier in this video, one would hope that if there are frivolous referrals, that the police will deal with that appropriately and professionally and intelligently. But we know, in the case of Lucy Letby, that's going to go down as the most prominent miscarriage of justice in British history, in my opinion. We know in that case it was referred to the police with no evidence. We know that because the police said that themselves. So that has gone from a situation in which the case is referred to no evidence other than this slight statistical coincidence, this slight correlation, to someone being banged up for 15 life sentences. And the woman on your screen now is going to say that needs to happen over and over again every time anyone has any suspicions. And then now also is this culture of paranoia that's been created by the Lucy Letby case, by the publicising of the Lucy Letby case. It's well known about in healthcare settings, of course. And altogether, this adds up to a pretty dangerous recipe, in my opinion. So when I mentioned earlier that there's a race against time, there is now literally a race against time to prevent this. Hopefully it would become prominent enough that perhaps the inquiry could be paused before the recommendations are published, or perhaps Lucy Letby can be exonerated before these recommendations get passed into law. I don't entirely know the process of the recommendations being converted into something that is legally binding. I know it's a slow process in Parliament, so that would give a certain period of time, but this is incredibly dangerous. I've written a title to this video that might look clickbaity, but I think it's not intended to be clickbaity. It's just my genuine opinion that this is phenomenally dangerous. And that would apply if the Thirlwall Inquiry had paid attention to its own documents. I know for a fact that it hasn't. I know for a fact that there's all manner of information that creates a completely different impression to the narrative that has been stage managed in this public inquiry to give an impression to the public. And the recommendations are now going to be written based on this impression. And yet the inquiry has ignored just an almost innumerable amount of documents, and it inordinate amount of information from its own documents. And that's an extraordinary situation. It's a very regrettable situation, and it's one that could have an enormously negative impact on many people's lives, on liberty in this country, and on the healthcare system as a whole. So I really wanted to make a video just highlighting this, because I think it's something that definitely hasn't escaped people's attention, because people followed the Thirlwall Inquiry quite closely. But I think people don't realise how close we are to having a situation where healthcare professionals, particularly nurses, could end up being referred to the police in relatively large numbers. I mean, I don't know what impact it will have on the number of referrals that are made, but they're almost inevitably going to go up. It's almost inevitably going to increase. And as we've seen with Lucy's case, and now this case in Birmingham, there's been a few, I don't know if it was infants, but there's been a few deaths. I can't recall if the article said they were infants or not, but there's been a few deaths on this unit at Birmingham because of the fallout from the Lucy Letby case. Someone has probably thought, oh, we better refer it to the police. There's probably someone's probably seen, oh, there's some readings we didn't like. Oh, this nurse has been on duty. Oh, that's all we need. Let's get the police involved. So refer it to the police. The police don't think, well, this could be an entirely frivolous case. Immediately, they start interviewing the nurse. They probably would have charged the nurse, I would suggest, by now, because they don't require concrete evidence. We know that. And bear in mind, this has already happened, and this is before the recommendations. So this is before the recommendations require hospitals and other healthcare settings to immediately refer anything. So theoretically, if I was working in a hospital, I went to an executive and said, I believe this person has engaged in wrongdoing. Theoretically, they've got to refer it immediately. They don't require any evidence from me. They don't require anything of substance from me. If they don't immediately refer this to the police, then they're the one that becomes guilty of committing a criminal offence. And I would guess the penalties are going to be quite severe, given the prominence of this case and this inquiry. So overall, it's a pretty chilling picture, but it's one that is emerging and that is on the verge of actually happening. So I wanted to make a video just addressing that, and I hope it can be prevented in some way, because it will be catastrophic. Anyway, that's all I have to say in this video. I really appreciated the support I've received from the last video. A lot of people seem to really enjoy that one. I was a bit worried that I'd gone too far, but then I watched it back and I thought, no, I stand by everything I said in that video. So I think it was fine. Generally, I'd like to strike a more neutral tone, but I just thought that so-called documentary was so bad, it just needed to get good kicking, really. So yeah, if you have any comments, queries, questions, observations, etc., please do leave them, and I'll look forward to reading them.